Hi everyone, this is the second property review session, and today I'll be going over all of the material covered in class during the last 4 weeks, starting off with the rule against perpetuities. Then I'll go over all of the unfinished hypos, which are primarily just future interest ones and rule against perpetuities ones. So let's go ahead and get started. Okay, so the first thing, before I even talk about the rule against perpetuities, is I'll say that if you're struggling to identify future interests, it will definitely affect your ability to apply the rule against perpetuities and just co-tenancy rules. So my advice would be to study now, review, go back and redo some of those hypos, and hopefully that will just really cement the concepts in your mind. So the rule against perpetuities is a rule that tests the validity of contingent future interests. Every future interest must pass the RAP analysis in order for it to be valid and enforceable. Your goal when undertaking the RAP analysis is really just to find a single validating life. So in a nutshell, you want to be able to tell a story where the interest must, not should or could, but must vest within 21 years from the end of some life in being at the time of the transfer. If you're able to show this, then the interest is valid. If you can't, then it's not. Okay, so with that general background in mind, let's take a look at the 5-step process outlined by Professor Fagundes. So remember that the RAP applies to individual interest within a conveyance, not to the conveyance as a whole. So the question then is to which specific interest does it apply? Luckily, there's only 3 that you have to worry about, as it only applies to contingent remainders, executory interests, and vested remainders subject to open. So if you have a present possessory estate or a future interest in a grantor, then you don't even have to worry about the RAP. Step 2, you pick the measuring life most likely to validate the interests. And if any life can validate the interest, then it's good. As Professor Fagundes mentioned, it can technically be any person, but the rule of thumb here is really to pick someone who has control over the interest. In other words, the person you're choosing should be someone who is mentioned, within the hypo. So moving on to step 3, then you determine when the interest will vest or fail. Make sure not to confuse vesting with when an interest becomes possessory. Vesting just means when something is certain to happen. So for example, if the problem set O to A, then to A's first child, and A has 3 kids, then that is a vested interest because A has a first child, but it's not a possessory interest yet. And then I guess I'll give an example also as to when an interest would fail, would be certain to fail. So if it said O to A, then to A's widow, when A dies, the interest must either vest or fail, depending on whether A left a widow. So that would, in that case, we would say that we know for sure whether it will vest or fail at the time of A's death. Step 4 is really just the easy part. This is where you apply the RAP. So here you ask if the interest must vest or fail within 21 years of the end of the measuring life. If the answer is yes, then the interest is valid. If no, then you should consider other plausible validating life. And then in step 5, you remove any invalid interests and keep the valid ones. Moving on to the rule of convenience. So the rule of convenience is really a doctrine that specifies that a class as designated in a class gift closes when a class member is entitled to a distribution of his or her share of the gift. I really like to think of the rule of convenience in conjunction with the reverse Three Musketeers rule, which, that rule says that if a gift is open to an open class, but some members may vest too remotely, it would normally be invalid as to all of the class members. So think about O to A for life, then to A's children who reach the age of 25, and A currently has 2 children, B who is 27, and C who is 23. Because the unborns in that scenario could reach the age of 25 21 years after the death of A, who in this case would be the validating life, their interest would be invalid. Because of the Three Musketeers rules, the invalid interest would cause the valid ones to also be invalid. However, the rule of convenience applies, by saving the interest of some of the class members. So in this example, B and C would be saved since they are currently in existence, while the interest of the unborns would be deemed to be invalid. So I think of them together, and I think of it almost as a compromise. So normally all of the interests would be invalid. We apply the rule of convenience, save some interests, and give up some. Yeah, so remember that when you have a rule of convenience issue, that it saves the interest of all those born before the class closes, and pay really close attention to the language in the conveyance. So if there is a validating life, then the class closes upon the death of that validating life, and every class member alive at the time has a qualified future interest. If you cannot point to a validating life, but there are vested interests, then the class is just considered closed upon conveyance. And I'll just, flag this. Be on the lookout for things that sound like class gifts, but really are not. An example of this would be O to A's first child. This would not be a class gift because it's only ever going to go to one person, but it sounds like a class gift because it just says to a child, which I guess in theory could be, it's not specifying an individual. All right. So after the rule against perpetuities, you all covered co-ownership. And co-ownership really is just when multiple people own property at the same time. And the question here is who are the owners? There's three main types of concurrent ownership: tenancy in common, joint tenancy, and tenancy by the entirety. So starting off with tenancy in common, this is where when owners, of which there can be an unlimited number of them, share separate but undivided interest in the whole property. Undivided interest just means that each of those multiple owners is simultaneously entitled to use and possession of the whole parcel. So in other words, every one of them can also exclude non-owners, and they can, use the property as they wish. Despite the disparity in ownership interests, so say an individual has a 90% interest while the other has a 10% interest, the relative use rights do not change. The relative percentage interests are really more about economic benefits and costs rather than the ability of one of those individuals to be able to use the property. The relative ownership interest really only applies when you're selling the land. That's where you will kind of look at that percentage and determine who owes what, or who gets what percentage of the profits. Separate interests, as I said, you can do. It just means that you can do with your share whatever you want, so long as it doesn't prejudice another co-owner. Tenancy in common, really important to know. This is the core default, and it's the most basic type of co-ownership. So if you're ever in doubt, and you can't tell what it is, it's most likely a tenancy in common. And if there is no specificity, then we just assume equal shares. So there's two people, it'd be a 50-50 split. In a tenancy in common, owners can voluntarily move for partition, and I'll cover that in the next slide. But essentially it just means that if you can't work out something privately, you have a right to judicial action that will either slice up the land and give you a separate physical portion, or force a sale and give you your rightful share. So tenancy in common, these can arise by deed, by device, or by severance, and the shares are descendable, divisible, and saleable. I guess I'll go ahead and define severance here, although that's also something I'll cover later on. So severance is just, it's when someone can exit a joint tenancy or a tenancy by the entirety and enter a tenancy in common without having to partition the land. So if you sever either of those forms of co-ownership, it automatically results in a tenancy in common. So a joint tenancy, this is just a single undivided interest in the property, and we think of it as a singular unit that owns the whole. You form this, depending on the jurisdiction. The majority rule is you need explicit language. so preferably to X and Y as joint tenants with right of survivorship. However, there is a minority approach out there, and it's actually the common law, which looks to the four unities. And it says that, it presumptively gives rise to a joint tenancy, even if you didn't use that explicit language. The four unities are time, instrument, rights of possession, and the amount of the interest. So with time, you need to be able to, or you need to have conveyed to both individuals at the same time. The instrument just means that you did so via the same deed. Rights of possession means that the parties got the same basic rights of possession, and the amount of the interest needs to be the same. I'll point out that Texas acknowledges the four unities, so it is a minority jurisdiction in this regard, but it's always safe to just use that explicit language to kind of avoid that four unities analysis. Another thing, the last thing I'll say about this is, so the main distinguishing feature and primary source of appeal of a joint tenancy is the right of survivorship. And it's really nice because, you avoid probate upon death, and the surviving joint tenant automatically owns the entire real property upon the death of the decedent joint tenant. You can sever this by conveyance to a stranger to the title, by consent, and by partition. It cannot be severed by will, and you should be on the lookout for implicit severances. So per Boswell, which is one of the cases that you all looked at, a lease to a third party does not sever the tenancy. The catch, though, is that upon the death of that joint tenant, that interest will also evaporate, becoming unenforceable against the surviving joint tenant. Mortgages, it's a little bit more of a tricky analysis. It depends on the jurisdiction. In a majority, in lien theory states, which is the majority of jurisdictions, mortgages do not implicitly sever a joint tenancy, nor do they survive the death of a solely conveying joint tenant. On the other hand, in title theory states, of which Texas is one of them, it is understood to effectuate severance. So tenancy by the entirety, this is just we think of it as a unit that owns the whole, but not separate, undivided shares of the whole. So with tenancy by the entirety, you have them in marriages, and there is no right of partition. These are they exclusively exist in common law jurisdictions. And then some tenancy by the entirety states assume that conveyance to married couples is presumptively tenancy by the entirety, while others require explicit language in a conveyance. And that explicit language is to A and B as tenants by the entirety. Okay, so moving on to partition, the case that you all looked at for this was Arkland. And there's essentially two types of partition in kind, which is the preferred method, and then partition by sale. Partition in kind is preferred because courts don't really like to force people to sell anything. They prefer private agreements. And also just it's preferred because of the concept of non-fungibility. Essentially the idea that you can't reduce property to a dollar value because each line is so distinctive, and there's the emotional attachment associated with the land. And then partition in kind is essentially what you all ended up seeing in Arkland. Partition by sale, on the other hand, is a little bit of a different analysis. This is where the property is sold and the proceeds are split. As I said, this is not the preferred method, and so you'll only ever really have this if partition in kind is not practicable. So let's just say you have, there was a hypo with like a rocking chair. If you split it in half, obviously no one can use it, so it's not super practical. And then also the result needs to be fair to both parties. This is, I guess, where you would have, depending on the jurisdiction, different types of analysis. If you don't know which jurisdiction you're in and what they look at, consider applying both the Pareto and the Kaldor-Hicks efficiency standards. So the two different considerations, Pareto, you essentially, it only works if at least one person is made better off and no one is made worse off. This is obviously a really high standard. Whereas with Kaldor-Hicks, it it is okay as long as on balance the parties are better off. If you have this, then you can have partition by sale. So with Kaldor-Hicks, technically one party can be net negative, but if the situation as a whole is net positive, then that's okay. In Texas, partition by sale is not a super high threshold, as Texas is really an economically oriented jurisdiction with respect to this issue. So, slicing up the land to partition in kind would substantially reduce the value. Then, you just do it by sale. Okay, so then the duties of co-tenants, you all looked at Estevez for this particular part of the class, and with the duties of co-tenants, you're mainly asking, or you're looking at rather, the duties both before and after occupancy. And the fundamental premise is that equal co-tenants have to share in the cost and profits, but how they share in these things depends on what it is that we are talking about. So looking at rents, the majority rule is neither owes rent to the other party. The minority rule, which is what you guys saw in Estevez, is that there is possible rent obligations by the sole occupier when occupancy ends. Profits need to be shared during ownership, and it includes rents from third parties. So let's say that it is A and B, and A leases the land to someone else and is getting $10,000 a month, assuming a 50-50 ownership interests in those two joint tenants. A would owe $5,000 a month to the other party. Taxes and mortgages, the majority rule is that these are shared, while the minority rule says that only the occupying owner needs to pay. I also add that co-tenant for taxes and mortgages, co-tenants who pay more than their shares are entitled to equitable, like a payback, I guess, from the other co-tenants. Improvements, there is no right of repayment during occupancy. Rather, this will just be reflected in an increased market value at the time of sale. If one co-tenant ends up paying, then they get the entire increased profit when sold. So let's just say someone adds a pool to the house, and the market value of the house increases by $50,000. That $50,000 will solely go to the person who put the money down towards the construction of that pool. Necessary repairs. So there is no repayment during occupancy, but it can be the person who ends up paying for the necessary repairs can be credited for those repairs at the time of sale. So again, let's assume that there's a broken door or a pipe bursts, and they spend $2,000 trying to fix that. They can't go to the other tenant and immediately seek repayment for that, but that would just be something that will be they'll recover at the time of sale. All right, so then going on to marital property, there are two types of states, I guess. There's community property states and there's common law marital property states. With the community property states, the main way of looking at it is starting off with Louisiana and then working clockwise up towards the West Coast. You skip Oregon and include Idaho and then Wisconsin. And there's two other states, I can't remember off the top of my head, that you can opt into. But the main premise, I guess, with community property states is that the marital community owns what each spouse earns during the marriage, as well as any gifts to the marital community. The spouses here separately own premarital property, as well as what they acquire via gift, descent, or device during that marriage. common law marital property states are essentially all the other ones. So think of this as the majority. Here, the spouses are regarded as separate entities, and they each own what they earn, inherit, or are given. This is where I guess we looked at the tenancy by the entireties, which was the concept emphasized in Sawada versus Endo. And the rule coming out of Sawada is that any separate conveyance by either spouse is void, including debt. So the spouse has to get the other one to sign off on a conveyance. Neither can make a move with respect to the shared property unless they can get the other person to sign off. Obviously, this is massive. It offers massive creditor protection, as all property held in a tenancy by the entirety. It's off limits to those creditors. This is a rule in a majority of states. But federal tax liens, as Professor Fagundes mentioned in class, those do attach to property because that's, federal law. It's a product of the Supremacy Clause. Those will apply regardless if there's a tenancy by the entirety. The minority view is that, those can be conveyed unilaterally. Okay, so then we looked at divorce, and the initial rule for property, when it comes to divorces, was equitable distribution, which was essentially we asked what was, a fair distribution, an equal distribution assumption. We start off with a 50-50 presumption, and then, we give 50-50 to each person, and then we allow the other person to argue for why they should get more. So in the divorce case, we looked at Guy v. Guy, and in this particular case, there was an educational degree, and the main question was whether that was part of the marital estate. From a formalistic perspective, it wouldn't be, because property, the constituent rights of property are to use, to exclude, and to transfer. Obviously, an educational degree is non-transferable, as only the person with the degree can actually use it. The majority view here is that property only includes things that have those three typical property characteristics, while a minority of jurisdiction look more at a functionalist view, and they essentially ask whether the property has any sort of value. The court in Guy v. Guy took a middle approach, and they said that while the degree was not property, the wife needed to reimburse the husband via alimony for the costs incurred. I guess I didn't include this in the PowerPoint slides, but it wasn't covered super in depth, so I'll just mention it really briefly. Remember that in common law states, not community property states, there's an elective share statute, which essentially entitles the surviving spouse to a baseline portion of the decedent estate. So essentially, if your spouse disinherits you in his or her will, then you as the surviving spouse get a minimum share of their estate. Usually it's about half or a third. This does not exist in community property estate because, as I mentioned before, we consider just the community, the marital community, to essentially own the property in 50-50 ratio. So it doesn't really apply. And the elective share also doesn't really apply to joint tenancies or to life insurance proceeds. And you can't really go around it by gifting your stuff. That wouldn't really work. All right, so then we looked at leasehold estates, which are another form of co-ownership. We say that they're another form of co-ownership because the owner, so in other words, the landlord, retains the right to transfer, but they cede the right to use and exclude. So a lease is a partial transfer of the essential property rights, with the tenant, just being able to live there for the time being. As Professor Fagundes mentioned, leaseholds meld property and contract law. So the four different types of leases are term of years, periodic tenancy, tenancy at will, and tenancy at sufferance. So with the term of years, it's determined by any period with a fixed start and end date. So let's say it says from November 1st of 2022 to December 1st of 2023. You can look at calendar dates and when it starts and when it ends. In a term of years, the tenant has the right to occupy, or the right to occupy automatically terminates upon that end date. And we think of the landlord as having kind of a reversionary interest. The defining feature is as I said, is a fixed ending time. With the periodic tenancy, it is a span determined by succeeding periods. So here it'll say something like month to month or year to year. The termination notice generally correlates to the length of a period. So if you have a month-to-month lease, typically that means you have to give a month's notice before it ends. Although sometimes it arises by implication. So if it's a year to year, in a commercial setting, typically it won't be a year-long requirement because that's just such a generous amount of time. So you'll have something else. Also, these usually arise when lease term ends, and a landlord chooses not to ask you to leave, and you just keep living there. I think Professor Fagundes mentioned this in class. It's most commonly the practice that a tenant has a term of years that then becomes a periodic tenancy. Tenancy at will, these have no fixed periods, and they are usually terminable by either party upon reasonable notice. In Texas, the requirement is that there is fair notice. In most jurisdictions, though, you have to give a month notice so that it ends up looking a lot like a month-to-month tenancy. This is also what happens when a lease term fails. So if a lease if it has an unenforceable term, such as a lease for life, you just have a tenancy at will because that's not enforceable. And then tenancy at sufferance. These only follow holdover tenancies, which are essentially, it's a situation where the landlord says to the tenant that, he wants him out, but then the tenant stays. In that situation, a landlord may either evict or impose a tenancy at sufferance. When that happens, the tenant can either leave, but, would owe damages in the amount of whatever the implied lease terms were. And, in order to avoid abuse, state law limits the length of term that the landlord can impose. Okay, so then we looked at subleases versus assignments, and the case that we looked at here was Ernst v. Condit. So I'll define the terms really quickly. So a sublease is essentially where a tenant executes a completely new agreement with a subtenant, and then the tenant remains in their initial relationship with the landlord. They had just executed essentially just an additional sub-agreement. So the relationship between the landlord and the initial tenant is in place. Both have contractual relationships with each other. But now there's a relationship that is formed between the tenant and the subtenant that entails the same obligations. An assignment, on the other hand, is where a tenant replaces himself with a new tenant. So essentially, gives his lease to someone else, and some degree of liability between the landlord and the assignee. So in a contractual sense, the landlord remains connected to the initial tenant, but in a property sense, we say that there's now privity of estate between the landlord and the assignee, which means that the landlord now has options to sue either the tenant or the assignee should there be an issue. And specifically, landlord can sue for default on a property theory against the assignee, while only on a contract theory against the original tenant. How do you know if you have one of these things? Well, an assignment is when you give someone all the amount of time left, all the terms, everything, also the amount of what you possess. So if you have a lease that it's, it's like a 2-bedroom apartment, but you only give a room, then we wouldn't say that you have an assignment because you've retained an interest. A sublease, on the other hand, is just when you give a tenant, something less than what you have. Depending on the jurisdiction, so the majority of them look at an objective test. They'll say, what was the substance of what you did? They won't really look at the language necessarily. While a minority of jurisdictions look at the subjective test, they look at the intent of the parties. Something to keep in mind here is whether there's been an novation. So in other words, has there been a cancellation of a lease and a new lease signed? If that is the case, then that's something else entirely. I'll quickly mention, just for purposes of hypos, I guess, that if you're a landlord, you generally don't want a tenant to sublease or assign, because landlords generally go through this really extensive process trying to determine, who the tenant will be. So there are 3 ways in which landlords can limit subleases or assignments. The 3 options are the sole discretion clause, reasonableness clause, and silent consent clauses. The sole discretion clause essentially just says that landlord can refuse any of these for whatever reason. Reasonableness, it goes off of a commercial reasonable standard, and silent consent clauses just don't say anything. There are different approaches for interpreting sole discretion in commercial versus residential leases. In commercial settings, this is a minority view, but it is a growing trend. We say that there needs to be an objective business-based reason for refusing to sublease or assign. In a residential lease, on the other hand, the landlord has sole discretion. And this is generally just because, people have idiosyncratic tendencies, and, we give them, there's more weight attached to that in the residential setting. All right, so then we looked at eviction, specifically retaliatory eviction. And the case here that you all looked at was Elk Creek Management. So here, with retaliatory eviction laws, mainly it's about state statutes precluding landlords from specific conduct, so say raising rent or something like that, after the exercise of a tenant right. So say they, file a legitimate complaint with the landlord. When you have a retaliatory eviction law per Elk Creek, you don't have to prove that the landlord harmed the tenant. You just have to prove a but-for standard, or there's 2 causes, that either one would meet the substantial factor test. As long as you can show that in some causal sense, the tenant's privileged conduct led to the landlord's prohibited conduct, that causal relationship will meet the test. And this is actually the test followed by Texas and many other states. There is also a presumption model, which essentially says that any adverse action by a landlord within a certain period of time of a tenant exercising their right is presumed to be adverse and bars eviction. I will say also that it doesn't really matter if the retaliatory eviction, if it was like a good faith basis, like the property management, giving notice because they plan on renovating to pay for cost of rewiring a unit. If by itself, giving notice that you needed to remodel, it might be okay on its own, but not if the reason you chose to do that flowed from from making a complaint about something specific. All right, so then there were some miscellaneous leasehold doctrines that I've listed out for you all. One was the duty to mitigate, which applies to tenant abandonment, not surrender. So remember that surrender is essentially when you have a landlord and a tenant and they agree to end a lease early. So we would say that a tenant has surrendered the premises. An abandonment, on the other hand, is when a tenant vacates without justification and stops paying rent. This is the only time when the duty to mitigate arises. So what are the mechanics of this? Well, the landlord needs to make reasonable efforts to mitigate the losses associated with a tenant's breach of a lease, and they can recover all the rent that the tenant should have paid under a lease that is not paid by the new tenant. This is an affirmative obligation, for the landlord. But if they do this, then they can recover all of the money. If the landlord does not make an effort, then the landlord can forget about the money, and then the tenant, of course, all owes the landlord all losses that cannot be reasonably mitigated. I didn't include this here. I think Professor Fagundes included this on a PowerPoint slide, but reasonable efforts. So that essentially means advertising and showing a unit. You need to ask for reasonable rent and terms. The tenant needs to pay associated costs, while the landlord bears the burden of proof. The Sommer case requires that the landlord treat the tenant's unit as if it were one of the vacant stock, which means the landlord needs to show the same diligence to all apartments. Okay, so moving on to the covenant of quiet enjoyment. The covenant of quiet enjoyment is a covenant implied in all leases where the landlord promises not to wrongfully interfere with the tenant's possession of the premises. A constructive eviction, which is tied to the covenant of quiet enjoyment, is a remedy that the tenants can choose to opt in for if the covenant of quiet enjoyment is violated. So the constructive eviction occurs when a tenant leaves a lease premise due to wrongful conduct by the landlord that materially interferes with the tenant's beneficial use and enjoyment. So think of this in a sense as being, you're effectively kicked out. The doctrine, it's important to note, it captures both omissions as well as actions. So this was the Kaminsky case. The landlord was not sending out the protesters onto the property, but they were also not doing anything about it. So that's an omission. And the takeaway from the Kaminsky case is that omission and inaction, as well as affirmative conduct, can violate the covenant of quiet enjoyment. Also, Paolucci, I'll just flag kind of the main takeaway there. The tenant needs to give the landlord notice and opportunity to cure. And once they've done this, the tenant needs to abandon the premises within some reasonable time after the landlord has failed to remedy the situation. So, in that case, I think it was just the tenant provided notice, but then they renewed and stayed, a little bit, what was it, like close to 6 years or something. That's, not a reasonable time. So by staying that amount of time, the tenant forfeited the constructive, the constructive eviction remedy. All right, so then you all looked at the implied warranty of habitability. And the only thing I'll say about this is that it's essentially just a consumer guarantee that when a tenant leases from the landlord will keep the unit, habitable. The standard here is safe, clean, and safe for human habitation. And, as opposed to the covenant of quiet enjoyment, the implied warranty of habitability only applies to residential housing. So one view of this, which was the one that was covered in the Wade v. Job case, is that you look at code violations to see if there's been a violation of the implied warranty of habitability. And the main thing to consider is that minor violations they're not sufficient by themselves to establish this. An alternate view, though, is just health and safety. It needs to be safe, clean, and fit for human habitation. Really important to remember that the implied warranty of habitability cannot be waived. So, whatever disclosure is given by the landlord is totally irrelevant. And then, just to remember that this is a product of statute. All right, so then what do you get whenever, this is violated? Professor Frigunda said, essentially there's a lot of possibilities. You can get rent, you can withhold rent, you can pay diminished rent, you can move out and get rent back. If you have to move, those relocation expenses will be paid back. If you incur costs, repair costs, the landlord will have to pay for those back, and punitive damages can also apply. All right, so moving on to the Fair Housing Act, which is the last topic we'll cover. This applies to dwellings, and it does not include roommates within the same home. So it's important to consider that it's not just about selling, it's about selling or renting property, but it encompasses a whole variety of things, such as advertising, obviously can't be discriminatory, covers selling and renting, terms and conditions, which are, would be like charging more rent or doing other things, which in effect, would amount to discrimination, decline to show property or, adjacent behaviors like that. The protected groups are race, color, religion, sex, disability, nationality, and familial status, which, that last one just means that there is at least one child and at least one parental figure. Important to remember that any other groups not mentioned within the ones that I just listed on the PowerPoint slide, are not covered. So, age, veterans, professions, people in socioeconomic groups, all of those are not covered. And then there is an exemption, as you also in roommates, the roommates case, which does not apply to roommates, and also there is an exemption for small owner-occupied dwellings, as well as single-family houses sold by the owner if they own less than 4 houses. All right. So then whenever you have an FHA claim, there's 2 ways, I guess, of essentially, there's 2 issues at play. If there's, disparate treatment or disparate impact, there's, a different route that you can take. So starting off with disparate treatment, the first question you ask is whether the plaintiff needs to make a prima facie case, which, depending, there's 2 ways, I guess, of getting at this. So if you're talking about, let's say, a housing authority or it's some sort of macro issue, so take, let's say the Texas Department of, Houston, of Housing Houston office, then that will have to be, a statistical argument. And then in that case, you need to show that the department has been citing low-income housing in, minority areas disproportionately, and that's then reasonable. If, on the other hand, we're talking about an individual or a micro level, then you just have to show that there's been, a rejection of a qualified applicant in a protected class. Oftentimes in these cases, you might also have, testers, which is essentially just when HUD sends out people, who pretend to be renters, but really are just investigators trying to make sure that there's no discriminatory practices going on. Once the plaintiff has made, has presented their prima facie case, then the defendant gets a chance to offer legitimate explanations. So, here the defendant can say, it looks, weird, but it was actually, we denied the application really because it was due to a low FICO score, or we looked at the rental history and, in the last rented unit, that person only paid rent, half the time or something like that. And then, step 3, the plaintiff can rebut this explanation, as a pretext if they can show. So going back to the FICO example, if the plaintiff can show that other people with similar FICO scores were being offered the apartments, then clearly then that would be pretextual. And then lastly, there was the disparate impact. And for this one, there are three, the analysis is a little bit different. So here we ask if the plaintiff, the plaintiff needs to show clear statistical evidence of causation between the policy and the discriminatory effect. The defendant, after that, the defendant can state a legitimate business justification, uh, and they just have to give a reason, not that they don't have to prove that there was a less discriminatory alternative. That is what the plaintiff has to show in after the defendant makes a legitimate business justification. The plaintiff needs to be able to show that there was a way for the defendant to arrive at their legitimate business justification via a less discriminatory alternative. Okay, so I think this went on for a little bit longer than I thought, so I'm going to pause because I know some of you have already visited me in office hours and gone over the hypos. So I'll stop the recording and then I'll make another one for the hypos just so that it's not a super long recording.